গাইস আজকে দেখব we have already discussed regarding the schools of jurisprudence. Today's session is on point of Austin's theory, the criticism on point of this. Let's have a look, guys. This is the diagrammatical presentations. Our discussed matter is criticism. In our society, a lot of many critics. Austin, the father of English law, but the sound is not clear to me. Please, just you have to actually lock the door. Dear audience, today's session on point of criticism, on point of the definitions given by Austin. We find many, actually there are three elements or ingredients in the definitions of Austin. That can be said in such a way that the CSP. So what do you mean by CSP? C indicates the command, and here S indicates the sovereign, and the last P denotes punishment or the sanction. So what do you mean by punishment? Look, let's have a look here. Dear audience, Russell Khan is watching, Harun Rashid is watching. In the definition of Austin's, we find three ingredients of law. Yeah, the first one is the command, and another is sovereign, and the last, the punishment. So punishment is a sanction, such as fine, penalty, loss of property, assist against a person who has violated the law. So all the three ingredients of laws are found in the definition of Austin. In modern period, there are many critics, against the definition of Austin. Now we have to see what the critics. Let's have a look, please. The sound is not clear to me, Mr. Shabul and dear audience, and okay, clear to me. Let's move. Just today's sessions on point of the definition of Austin's. Then we find three ingredients of laws like this: command, sovereign, and punishment. Now we would like to focus on point of this, how the critics criticize the definitions given by the Austin. First of all, I would like to focus on point of sanction. Let's have a look. Sanction, this is punishment. By another name of punishment is sanction. Let's have a look. Punishment. On point of this punishment or the sanction, many critics criticize in tackling this perspective or in tracking this approach. Let's have a look. So how we actually criticize this view which is given by Austin in jurisprudence? Let's have a look. We know in the world, laws are of many kinds. For example, this is civil law or the common law. In terms of civil law, sometimes we cannot find any punishment in the world. And that's why Austin is criticized by many other critics. Let's have a look. There it is. And guys, many other actually observe the discussion of mine on point of the criticism on the definition of Austin. Let's have a look. The first one is critical issue is punishment or the sanction, which is not sin in the definition of Austin. And the next. So number one is denied or ignored. And the next. Next is president. Austin, what do you mean by president? Already we have discussed regarding this in earlier class. President, already the term president is ignored by Mr. Austin. So the critics criticize in tackling this perspective or in tackling this approach. So president is not found in the definition of Austin Shahid. And not only that, president. Now we have to make it clear to you that what do we mean by presidents? Let's have a look. The presidents we have to mention in such a way that the Monica Gandhi versus Union of India. Not only that, several leading presidents, the Marbury versus Madison. In our country, in domestic arena, we found that Dr. Mohiuddin Farooqi versus Bangladesh. $49 Appellate Division 1, maybe. So those are the presidents. Already Austin has denied, ignored in his definition, in his famous definition. So there is an opportunity to criticize the approach which is played by Austin. Let's have a look. And the term is that on what point Austin criticized. Actually, Austinian definition is criticized. Custom. Custom is ignored. Custom is ignored by Austin. In his definition of law, we cannot find custom at all. So there is an opportunity to criticize the definition of Austin. Dear audience, guys, it is clear to you. very simple to you that the Austin has defined laws that we find that the command, sovereign, and punishment or the sanction. Only 3 ingredients are found in his definition. But we cannot find the criticize in terms of civil law. We cannot find any punishment. Well, the precedent is ignored and the custom is ignored. In the leading case, in studying the Hindu law, you have already gone through or read the collector of Madura versus Mathuram Linga. Versus Mithur Ramlinga. This is the leading case. This is judgment. What we find that's the clear proof of uses without by the written text of law. Written text of law. So what is the actually, what can say, judgment, which is perversing judgment, which is not found in the definition of Austin. Austin Sahib is not actually defined. Austin is not defining. There is the collector of Madura versus Mathuram Linga, where we see the clear proof of uses will outweigh the written text of law. And next, HIP is criticized. Several schools. Let's have a look here. There are many schools of jurisprudence. Many schools, that the HIP. Let's have a look. HIP. Here is indicates the historical school and this the philosophical school, economic schools. All those schools are ignored by Mr. Austin Sahib. Mr. Austin Sahib has denied or ignored that pros Sabiha Siddiqa Laila. Wow, Sabiha Siddiqa Laila is watching here, and another person, Mirza Ahmed, is watching. Let's have a look. So in the definition of Austin's, we cannot find historical school or the philosophical school, and the last, the economic schools. So there is an opportunity, there is a loophole of the lack of enough to criticize the definition given by the Austin. Let's have a look. Only the command of the sovereign is not taken into consideration in terms of the definition of law. Another critical moment is constitutional law. Let's have a look. In the definition of Austin's, we cannot find any approach in terms of constitutional law. Unfortunately, this is omitted from the side of view which is given by Austin. This is the constitutional law is not found in his definition. Sometimes in modern period, the belief in modern period, constitution is the supreme law of the land. Article 7 of the Constitution of Bangladesh prescribes that the Constitution is the supreme law of the land. Unfortunately, Mr. Austin Sahib ignored that. Mr. Austin Sahib has actually criticized by many other critics in the world. Ashraful LLB, wow, MD Hasib is watching. Yes, Hasib Sahib. Let's have a look. In the definition of Austin, there is no view or the approach in terms of constitutional law, which is found in Article 7 in the Constitution of ours. In Bangladesh Constitution, we find that the Article 7 prescribes in terms of that the Constitution is the supreme law of the land. Not only that, in the leading judgment, in this respect, like this, the Dr. Muhyiddin Farooqi versus Bangladesh. $49 appellate division, this is landmark decision, the High Supreme Court. Page number 1. So we find that the Constitution is the supreme law of the land. So why Austin actually ignores that? Why? I don't know. Do you know? Do you have any idea? Why Austin ignored constitutional law? I don't know. But I'm trying to know. I'm trying to play a vital role in this arena. And not only that, several critical moments has come into force against the definition of law given by Austin. Number 1, punishment. Number 2, precedent. Number 3, custom. And number 4, schools. Number 5, constitutional law. Those are ignored by Mr. Austin. And the number 6, personal law. You know, personal law? What do you mean by personal law? Personal laws, like Hindu laws or the Muslim laws. Those are totally ignored by Mr. Austin. So there is an opportunity, there is a loophole, the lacuna in his definition in terms of law. Guys, Borjahan Chaudhary is watching, Mr. Hasif is watching, I'm watching, and you have to share, please. That should be shared by you of all, and the whole nation will be benefited to observe this situational cases and point of criticisms and point of the definition of Austin. So the personal law is ignored, totally ignored by Mr. Austin, like the Hindu law or the Muslim law. Let's have a look. And the number 7, on what point actually Austin is criticized? We are discussing regarding them. Another term is that the international law. International. That is not international, it's international law. And sometimes in international law there are several sovereigns. So why the single sovereign is taken into consideration by Austin? In case of international law, they may have the opportunity to be a lot of sovereign power. So why this is not included in his definition? Let's have a look. Number 7, number 8. And the last but not least, several critical moments or critical approaches come into force. And I have actually mentioned number 1, 2, 3, 4, 5, 6, 7, 8, and the last. This well known to use, that is called JR. Now the question may arise from the side of you guys. What do you mean by JR? Here the J indicates the judicial and R indicates the judicial review. So the famous leading judgment or the landmark decision is Marbury versus Madison in US landmark judgment. It's the first leading cases on point of judicial review. the power of the judges. This is totally ignored by Austin. This is totally ignored by Austin. Keruhul AR, Purjahan Chaudhary, wow, they are watching the video. Okay, let's move. This is the judicial review. The first landmark decisions which has come into force in the world in the case Marbury versus Madison 1803. This is not found in the definition of Austin. So, in taking them, Mr. Austin is criticized in the world. Unfortunately, the famous book, The Province of Jurisprudence, this is the book which is written by Mr. Austin. We find there's three ingredients of laws like the command, subbrand and punishment, but those are not found in his definition. So it is clear to us that the criticism on point of the definition of Austin is clear to you of all guys. And again please, I would like to make it clear to you again, a comprehending lesson like this, the criticism on point. What points actually Austin is criticized? Number one, punishment. There is a punishment, another name is sanction. So what do you mean by punishment? Punishment is a sanction such as fine, penalty, or loss of property, assist against the persons who has violated the law. Unfortunately, in civil law, there may have no any existence of punishment. So he is criticized. Another term, number two, is the president. President is totally ignored by Mr. Austin. And that's why, let's have a look. The leading judgment Maneka Gandhi versus Union of India, or the Marbury versus Madison, Dr. Mohiuddin Faruqi versus Bangladesh, Anwar Hossain Chaudhary versus Bangladesh, 41 DLR Appellate Division 165. This is the landmark decision in our country. So those are ignored by Austin. And number three, custom. Custom is not included in his definition, and that's why he is criticized. And the four is called several schools in jurisprudence, like this, the historical schools, the pioneer of historical schools, Savigny, Montesquieu, or any other jurist who are actually opponent or against the definition of Austin. And number, not only that, the philosophical school is not found in his definition, or the economic Marx Engels, the social condition in our country, or the social status. No, that is the economic status of the people of Bangladesh is not found in the definition of Austin. Let's have a look. So several schools are ignored through the process of the definition given by Austin. And the custom, we have actually forgotten the measures which is in leading judgment or the landmark decision, collector of Madura versus Muthu Ramlingu. Since this is the leading judgment in Hindu law, when it is clear to us that the clear proof of uses will outweigh the written text of law. So how can he deny the discussion in terms of custom? Why? I don't know, but I'm trying to understand or comprehend that and make me clear to you, please guys. Another term is number 5. Here is quite clear to you, that's the constitutional law. That the constitutional law is totally ignored in his definition. Let's have a look. Why? The reason behind this, in his definitions we can find that command, subbrand and punishment. We cannot find the constitutional approach in this respect. But it is unfortunately omitted in his definition. Article 7 in our constitution, the supreme law of the land prescribes that the supreme law of the land is constitution, or the constitution is the supreme law of the land. So Austin denies that. And let's have a look. In modern time, constitution is supreme law of the land in the whole world. And number 6, let's have a look. The personal law, Hindu law or the Muslim law. The concept in terms of adoption, or the Smriti, whatever the sources of Hindu laws, or the Stridhana, or any of the charitable endowment, all the things are ignored through the process of Austinian definition and the Muslim law. In Muslim law, we can find that the marriage definition or the inheritance of Muslims, those are not found in his definition. Let's have a look. And the number 7. So number 7 prescribes that in a national law. Sometimes we see in a national area or in the present era that the geopolitical aspect, we find that the geopolitical aspect. There is a, what can say, like the international law, they may have the many other sovereign powers other than single sovereign power. So why he actually denies that? I don't know, guys. I don't know. If you have any idea regarding this, let me know regarding this, or let me actually comprehend that, please. Let's have a look. And the last but not least, here the indicating matters in jail, where the chair indicates that the judicial review and judicial review. Judicial review, the first leading case or the landmark decision is Marbury versus Madison 1803, is the US judgment. Why we can say that the election already you of all comprehend what is the judgment or the far-reaching judgment as given to the process of the Marshall. Justice Marshall has defined as judicial review. Unfortunately, we cannot find judicial review or the approach in terms of judicial review in the definition given by Austin. That's all, Your Honor. Today's is normal. So how actually you are the critic in our society? So sometimes we criticize for example, I'm discussing in terms of criticism on point of definition given by Austin. You are the critic. So criticize me. How you criticize me, whether I'm right or not. Today is Namo. Bye bye.